Hello and welcome to our channel where we delve into important legal and medical intersections that shape the world of reproductive medicine. Today, we're discussing a landmark case that has sparked significant debate, Gurvinder Singh versus Government of NCT of Delhi, which was decided on October 4, 2024. In this case, the petitioners, Gurvinder Singh and Harbir Kaur, sought the release of their late son's preserved semen sample to continue his lineage. Their son, Gurvinder Singh, tragically passed away at 30 due to non-Hodgkin's lymphoma. Before undergoing chemotherapy, he had preserved his semen at Sir Ganga Ram Hospital, being aware of the fertility risks involved. A writ of mandamus under Article 226 of Indian Constitution was filed in Delhi High Court, when the hospital where the semen was stored refused to release it to the parents of the deceased without a court order. This case falls under the purview of the Assisted Reproductive Technology Act, 2021, and the Surrogacy Regulation Act, 2021. The parents contended that the legislation did not explicitly bar their request and emphasized their right to preserve their son's legacy. The hospital and government claimed that the laws only permit reproductive assistance for couples or individuals facing infertility, not for bereaved parents wishing to use their deceased child's genetic material. The ART Act and SRA have strict guidelines. The ART Act defines intending couples and gamete donors, but does not account for posthumous requests by parents. The SRA restricts surrogacy to specific cases involving medical needs for infertility. Furthermore, the absence of prior explicit consent from the deceased complicates matters legally. In this case, the petitioners relied on precedents, which included a judgment by the New York Supreme Court. In a similar case, the parents were granted custody of their deceased son's genetic material posthumously. The court held that there is no prohibition against posthumous reproduction if the consent of the sperm owner or egg owner can be demonstrated. If the deceased had been married and had a spouse, the issues would not have been as complex. In the absence of a spouse, the question arises that, is there any prohibition on posthumous reproduction under the existing law? The answer is clearly in the negative. In the absence of any such prohibition, this court is unable to read a restriction where none exists. Accordingly, the court ordered the hospital to hand over the frozen semen sample of the deceased to his parents. This case highlights that IVF practitioners must ensure robust consent forms explicitly addressing the use of genetic material after a donor's death. The case also underscores the ambiguity in handling posthumous requests for genetic material. It also raises ethical dilemmas about the rights of parents, the deceased, and potential offspring. IVF clinics may face liability for failing to comply with consent or documentation requirements, and also misinterpreting or mishandling legal requests for genetic material. Let us know your thoughts in the comments. Should India's reproductive laws adapt to include cases like this? And how can we balance the legal, ethical, and emotional aspects of such sensitive issues? Don't forget to like, share, and subscribe for more insights into the intersection of medicine and law.